What is up, everybody? Hope all is well. Good afternoon. Let's go ahead and get started with the show.
Hey there, listen. So basically, based upon the rules of YouTube and the community guidelines, we have to make sure that we cover ourselves with the use of, if we're going to be using content, we have to recreate it, add some commentary to it, fix it up, whatever the case may be. It can never be the original. Anyways, this is my fair use, copyright, recreation, and just making sure that I abide by the community guidelines and the rules and regulations of YouTube in reusing this content.
What is up, everybody? Hope all is well. Come on in, everybody. We're going to go ahead and get through these papers really quick. Yes, sir. We're going to get through these papers really quick today. Come on in. Come on in. Come on in, everybody. Good afternoon. Good afternoon. Ooh. All right, everybody. Good afternoon. Let's go ahead and get through these papers really quick. So there's a reason why Diddy is not getting a bond. So let's go ahead and just get right into it. So the email that I have before you is from the Honorable Robin F. Tarnofsky, a United States Magistrate Judge, Southern District of New York. So, again, I'm reading these documents to you right here. This is from September the 17th, which is 10 days from today. So let's get right on to it, okay? All right, so if you're in here, please make sure you hit that like button, that subscribe button. Please make sure you share the video, share the video, share the video, share the video. Okay. All right. So this is from. Okay. This is from the United States Attorney, Damon Williams, has respectfully submitted this. So he sent this to the judge, sent this to all of Diddy's attorneys, everything, so on and so on. Okay. No, Marcus, we're only on one platform today. We're only on one platform today. We're going to be switching back and forth between Church Boy News and official King Jives Show. So that's what we're going to do. So like whatever I do here, I'm going to share content over there. Whatever I do there, I'm going to share content over here. Okay. Got it. All right. So it says, Dear Judge, the defendant Sean Combs, a.k.a. Puff Daddy, P. Diddy, a.k.a. PD, Love, was taken into custody this morning after a grand jury sitting in this district returned a 3-count indictment charging him with crimes related to his decade-long pattern of physical and sexual violence against multiple victims and his use of force, threats, and coercion to enact his will, protect his reputation, and fulfill his sexual desires. Maybe this is just... All right. What you said, Damon ain't playing? He ain't playing. The government respectfully submits this letter in anticipation of the defendant's appearance. Jesus, y'all, stop emailing. The government respectfully submits this letter in anticipation of the defendant's appearance before the courts, before his... Lord, y'all. Hey, I'm reading the thing online. Okay. All right, so let's read this again. Oh, you said essay. Thank you. The government respectfully submits this letter in anticipation of the defendant's appearance before this court later today and in support of the government's request for the defendant's detention pending trial. As set forth below, there is no condition, no combination of conditions that will reasonably assure that the appearance of the defendant as required and safety of others in the community, not to mention the integrity of the proceedings. As reflecting by the gravity of the charges in the indictment, the defendant is dangerous and poses an ongoing threat to the safety of the community. If released, here we go, y'all. If released, he remains a serious risk of flight despite the condition offered by his counsel. Mostly, the defendant also poses a significant risk of obstructing justice. Indeed, and also, as set forth below, during the course of the charged conditions of the charged conduct, the defendant has attempted to bribe security staff and threaten and interfere with witnesses to his criminal conduct. He has already tried to obstruct the government's investigation of this case, repeatedly contacting the victims and witnesses and feeding them false narratives of the events. As described in details below, there are simply no conditions that would ensure that the defendant's efforts to obstruct and tamper with witnesses will stop. The defendant therefore cannot overcome the statutory presumption in favor of detention, and the court should order him detained. All right. So, yeah, it's going there. All right. So, make sure y'all share the live. Please make sure you share the live. On September 17, 2024, an indictment returned by a federal grand jury sitting in the Southern District of New York. The indictment was unsealed, charging the defendant with racketeering conspiracy formed in or about 2008 through on or about the date of the indictment in violation of, right there, sex ST, I got to make sure I say that, ST from in or about 2009 through in or about 2018 in violation of the section right there, it's right there, and 2 counts. Okay. The interstate transportation to engage in prostitution from in or about 2009 through in or about 2024. In violation of 18 U.S.C. blah, 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 blah. 2 counts, 3 counts. Combs uses violence, threats, and coercion. Y'all make sure y'all share the video, okay? Share the live. We got, baby, it's 16 pages of this stuff. So we're going to go ahead and get through this really quick. So give me like an hour. We'll be okay. Since at least 2008, the defendant and other members associated of racketeering enterprise alleged in the indictment, the enterprise, which includes the defendant's multifaceted business empire, the Combs business, welded the power and prestige of defendant's reputation as a musician, entrepreneur, and figure in the entertainment industry to commit federal crimes, including racketeering, ST, and other offenses. As charged in the indictment, many of those crimes involve the SA and exploitation of women and other crimes of violence. All right. Sex trafficking and abuse. Yeah, make sure y'all hit that like button. Make sure y'all hit that like button. Thank you. Using the power and prestige of the enterprise, the defendant lured female victims into defendant's orbit, often under the pretense of a romantic relationship. The defendant then used force, threats of force, and coercion to cause those female victims to engage in S activities. Okay, y'all, I'm try not to say certain words because I don't want to get flagged or whatever the case may be. So I may just end up just saying them because at this point it's public record. So should nobody. Oh, you said throw it up on the screen. Okay, 1 second. All right, let me throw this up on the screen. I wish I had somebody to do this for me. That's okay. So y'all know I ain't lying. All right. Okay. Slide it on over there. I'm on page 2, right? Yeah, I'm on page 2. All right. There we go. So we're on. There we go, right there. All right. Here we go, y'all. Coercion. Okay, we're on 1, sex trafficking and abuse. Using the power and prestige of the enterprise, the defendant lured female victims into defendant's orbit, often under the pretense of a romantic relationship. The defendant then used, which included frequent sex acts with female commercial sex workers that defendant referred to as freak-offs. Freak-offs were elaborate sex performances that the defendant arranged, directed, masturbated during, and often electronically recorded. Freak-offs occurred regularly from at least in or around 2009 through this year, sometimes lasted multiple days. Jesus. Okay, I got to read like I'm the judge. And frequently involved multiple sex workers. The defendant arranged freak-offs with the assistance of members and associates of the enterprise, including employees of his business and the hotel rooms. Okay. Where they were staged, often sustained significant damages. Ooh, wait. And the hotel rooms where they were staged often sustained significant damages. Okay. The defendant. Okay. Y'all got to stop texting me while I'm doing this. Hold tight. I appreciate it. Y'all know I get distracted real easy and then folks get to complain about stuff. All right. The defendant ensured the victims would participate in freak-offs through coercion and violence. For instance, the defendant provided controlled substances, including ketamine, ecstasy, and I don't know, GHB. I don't know what that is, to female victims so they could and would continue to engage in freak-offs despite fatigue, physical and emotional exhaustion, and pain. Dang. In addition, both during the freak-offs and separate from the freak-offs, the defendant subjected female victims to physical, emotional, and verbal abuse, in part to cause them to engage in freak-offs. The defendant, where are we at? The defendant hit, kicked, threw objects at, and dragged female victims, sometimes by their hair. At least a dozen witnesses will confirm that they personally observed the defendant's violence towards women and or the injuries sustained by the women at the defendant's hands. One incident of the physical abuse occurred when a female victim was attempting to leave the hotel following a March 16th freak-off. The abuse was captured on video surveillance. I think that's the Cassie incident right there. I think that's what that is. This abuse was captured on video surveillance and publicly reported in May 2024. That is the Cassie incident. The defendant's assault often resulted in serious injuries to the victim that took days and weeks to heal. All right. For example, In approximately 2012 in Manhattan, the defendant paid over $46,000 to cover damages to a penthouse hotel room following a freak-off. An excerpt of the video footage is attached to the Exhibit A. So that's actually was what's on here, but I can't print that off, and plus y'all can't see if I print it off anyways. Let me see here. Okay, let me make sure everybody's in here. You said Diddy should have claimed he's producing porn. GHB equals ecstasy. No, they already said in here what it was, because it's they already said ecstasy. They said controlled substances including ketamine, because it's right there. Where are we at? Ketamine, ecstasy, right there. It's right there. So, and GABA hydroxybutyrate. I don't know what that is. Anyways, all right. So the defendant also okay, let's go to the next one. The defendant also coerced victims into participating in freak-offs by controlling their careers, finances, livelihood, and so I can see. All right. Finances, livelihood, and or housing, among other aspects of their lives, or by threatening to disseminate recordings of freak-offs. I told y'all that's what happened, and that's why he's sitting in there. The defendant used his considerable wealth and influence to make victims rely on him financially. For example, by paying for their rent or their cars, or by offering them career opportunities. Once he provided his support, the defendants repeatedly threatened to take it. The defendant repeatedly threatened to take it away to ensure that the victim's compliance with his demands, including their participation in freak-offs. Indeed, victims believed that they could not refuse the defendant's demands that they engaged in freak-offs without risking their financial security or career prospects, or without repercussions in the form of physical or emotional emotional abuse. Other victims, in addition to the defendant's physical, sexual, and emotional abuse of the romantic partners, the defendant repeatedly engaged in acts of violence directed towards his employees or others. As charged in the indictment, the defendant often assisted by members and associates of the enterprise engaged in kidnapping, arson, physical violence, such as throwing objects at people, throwing people to the ground, and hitting, dragging, choking, and shoving others. Numerous witnesses, including the defendant's employees and others, observed or experienced violence from the defendant's firsthand and sustained lasting trauma as a result. For example, in the early morning hours of December 22nd, 2011, the defendant and conspirators kidnapped an individual at gunpoint to facilitate breaking into and entering the residence of another individual. Multiple witnesses would testify at trial to the events surrounding the kidnapping and breaking in, the latter of which is corroborated by police reports and other reports. Approximately 2 weeks later, the defendant's co-conspirators set fire to an individual's vehicle. Who was that? I think that was Cassie's boyfriend. Yes. Approximately 2 weeks later, the defendant's co-conspirators set fire to an individual's vehicle by slicing open the car's convertible top and dropping and dropping a cocktail inside the interior. The police and fire department reported extensively document the arson and concluded that the fire was intentionally set. Okay. Multiple witnesses would testify to the defendant bragging about his role in destroying individuals' car. More broadly, since 2008, allegations of the defendant's physical abuse of women and others have been publicly reported to the media, including in Hollywood blogs and on podcasts. That's us. Law enforcement reports corroborate that police responded to several instances of the defendant's violence, including assaults against victims and other individuals. More recently, there has been an outpouring of other public allegations against the defendant, including claims of threats and physical and sexual violence, dating as far back as the 1990s, as far back as the 1990s. In short of the defendant's, okay, I don't know if I could show this. Y'all, I don't know if I can actually show y'all the weapon online. So I'm gonna have to show that much. So okay, so I'm gonna have to do that. In short of the defendant's violence tendencies are widely known. However, at no point during the past decade has the threats of public exposure or law enforcement intervention deterred the defendant from continuing his abuse. Okay. So this part is about the firearms. So I'm gonna have to take this down and then I'm gonna have to put it back up so that I don't get let me do that right now. Okay. The defendant and members of the enterprise included the defendant's security personnel, at times carried firearm, and the defendant himself carried and brandished firearm to intimidate and threaten others. Indeed, some victims were aware of the defendant's access to firearms. On one occasion, the defendant forced a female victim to And indeed, some victims were afraid of the defendant's access to firearms. On one occasion, the defendant forced a female victim to carry a firearm on his behalf, and another occasion, he pointed a firearm at a female victim. The defendant continues to have access to guns, including illegal firearms. In March 2024, during searches of the defendant's residence in Miami, Florida, and Los Angeles, California, law enforcement seized firearms and ammunition, including 3 AR-15s, which each with defaced serial numbers, as well as a large capacity drum magazine. As pictured below, I can't show you guys this, okay? As pictured below in a close-up image, okay, I'm not going to show that anyways. I'm not going to do that. As pictured below in a close-up image, the serial number of one of the AR-15s is visibly bored through and obscured. I don't know where he got it from. 2 of the 3 defaced AR-15s were found in the defendant's Miami bedroom closet, stored broken down in parts, along with magazines that were loaded with ammunition as depicted below. One of the AR-15s had a 10-round magazine loaded with 10 rounds of large caliber .223 ammunition, while the second AR-15 had a 30-round magazine loaded with 19 rounds of 223 ammunition. A large capacity drum magazine loaded with 59 rounds of 223 ammunition was seized from the defendant's Los Angeles resident and depicted below. That's a huge drum. What you think you is, Al Capone or something? Y'all, I really wish I could show y'all this. You see this? These drums? He had this in his house. AR-15s. These are two. Well, he had 3 AR-15s. Like three drums or something like that. Anyways, let me finish reading this. Oh, I'm getting to all that right now. In addition, 6 legally purchased guns. So he had 6 legally purchased guns with serial numbers, some of which were stored in gun safes. Safes were recovered from the defendant's residence. Although these particular guns, both the legal and illegal firearm, were seized, their presence in the defendant's homes demonstrated that the defendant has access to and surrounds himself with both guns and ammunition. Likewise, even if the defendants were personally restrained by the courts from obtaining new firearm himself, he could retain access to them through others. In some of the defendant's regular use of violence and threats of violence, as well as the coercion described above against the victims and others, for fostered and culture of fear in which these individuals believed that they were unable to reject the defendant's demands without subjecting themselves to physical or other abuse. Okay, let me put this back up. Whew. Jesus, Diddy. Okay. Oh, Lord. Okay. Right. Oh. Combs bribes witnesses and obstructed justice. Throughout the time period charged in the indictment, when the defendant faced possibility that his violence and criminal conduct could become public, the defendant and other members and associates of the enterprise pressured witnesses and victims not to report what they had saw or heard to the law enforcement, or to otherwise conceal the criminal conduct. That sounds like this. In the book. Sounds just like the book. This disclaimer. One of Kim Porter's final wishes was that this memoir diary be made public out of the protection of certain parties and their potential criminal activity. Some celebrity performers and events have been represented with the letter X. Due to their highly explosive nature, at some point in the future, this information will become revealed to the public. All right. All right. For example, as noted above, in March 2016, the defendant was captured on video surveillance striking, kicking, and dragging a woman in the public area of a hotel in an apparent attempt to prevent her from leaving a freak-off. When a member of the hotel security staff intervened, the defendant attempted to offer the hotel security officer a stack of cash to ensure his silence. After the security guard refused the defendant's bribe, and after coordination between the defendant and his employee, the defendant's staff contacted other members of the hotel security. At the same time, staff members were in close communication with the victim as the victim of the assault as well, all in an effort to cover up the defendant's assault and to prevent the incident from being publicly disclosed. Within days of the incident, the surveillance video disappeared from the hotel server. Similarly, throughout the time period charged in the indictment, members and associates of the enterprise have reached out to multiple victims on behalf of the defendants to convince them not to report the defendant's abuse. Most recently, in late 2023, immediately following public allegations of certain of the defense crimes, including his physical and sexual abuse of women, the defendant and other members of the enterprise made repeated phone calls to the victims and witnesses, during which they provided victims and witnesses false narratives of the events in an apparent effort to conceal the defendant's crimes. One of the two occasions, the defendant recorded those phone calls on a co-conspirator's cell phone, thereby attempting to obscure his involvement in the obstruction. Whew. While the indictment against the defendant was unsealed today, the investigation While the indictment against the defendant was unsealed today, the investigation into his and other co-conspirators conducted is active and ongoing. As a result of the ongoing investigation, as well as the defendant's charged conduct outlined above, including obstruction of justice and witnessing tampering, the government is limited in its ability to fully set forth all known details of the defendant's criminal conduct, including details of certain witnesses' testimony. To the extent the court has additionally, wait, can y'all see this? Okay, let me move this. Okay, there we go. Okay. Okay. To the extent the court has additionally questions about the charge offenses conducted or any other information set forth herein, the government is prepared to offer additional information on an ex parte basis. All right. Oh, Jesus. How can I put this on mute? Hold on, y'all. Put this on mute. My phone is going off. Okay. Okay. Applicable law under the Bail Reform Act, the numbers are right there. Federal courts are empowered to order a defendant's detention pending trial upon a determination that the defendant is either a danger to the community or a risk or flight. A finding of risk of flight must be supported by oh, y'all can't even see this. Hold on. There we go. A finding of risk of flight must be supported by a preponderance of evidence. I'm trying to get past all these numbers, y'all, so just bear with me. A finding of dangerousness must be supported by clear and a finding of dangerousness must be supported by clear and convincing evidence. Skip all those numbers. Obstruction of justice is another ground for pretrial detention by the courts. All right, you can see that information there. Courts in the Second Circuit have held that pretrial detention for obstruction of justice is appropriate as long as the government can establish by clear and convincing evidence that there exists a serious risk. The defendant would threaten, injure, or intimidate a prospective witness or juror. A serious risk of obstruction of justice may qualify as a danger to the community. All right. Bail Reform Acts lists 4 factors to be considered in the detention analysis: the nature and circumstances of the crimes charged, including whether the offenses is a violation of Section 1591, the weight of the evidence against the person, the history and the characteristics of the defendant, includes the person's character, past conduct, and financial resources, and the nature and seriousness of the danger to any person or the community that would be posed by the person's release. The concept of dangerousness encompasses not only the effect of a defendant's release on the safety of identifiable individuals, such as victims and witnesses, but also the danger that the defendant might engage in criminal activity to the detriment of the community. A finding of dangerousness does not require that the defendant have criminal history, particularly if a defendant has a history of domestic violence. Holding the prior acts of domestic violence are relevant to a determination of dangerousness because a willingness to strike. Wait, am I on the right one? Yeah, I'm on the right one. Willingness to strike loved ones offers prohibitive evidence of the tendency to violence and dangerousness towards others. Okay. Evidentiary rules do not apply to the detention hearings, and the government is entitled to present evidence by way of proffer, among other means. Okay. Where a judicial officer concludes after a hearing that no condition or combination of conditions will reasonably ensure the appearance of the one as required and the safety of any other person and the community, such judicial officers shall order the detention of the person before trial. Additionally, whereas here a defendant is charged with sex trafficking in violation, the number's right there. In other words, an offense under Chapter 77 of Title 18, it shall be presumed, subject to rebuttal, that no condition or combination of conditions will reasonably assure the appearance of the defendant as required and the safety of the community. Oh, Jesus, what is this? All right, hold on. How about this? This is a lot of stuff to read. How about you read it? Jeez. All right, the discussion. For the reasons set forth below, the defendant poses a significant danger to the community, both in terms of physical violence and obstructive conduct, as well as a risk flight. This is especially true given the nature of the criminal conduct and strong weight of the evidence. The defendants, therefore, cannot overcome the statutory presumption in favor of detention in this case. Okay. The defendant is charged with serious and violent crimes. As charged in the indictment, the defendant has physically and sexually abused women and others for a better part of 2 decades. The sex trafficking charge, based on the defendant's abusive conduct, count 2, carries with it a presumption of detention. And detention is particularly supported by the fact of this case. Since at least 2008, the defendant has engaged in serious acts of violence, including forcing and coercing women to participate in sexual activity, including sex acts with commercial sex workers, by using physical force, financial pressure, emotional abuse, and narcotics. These acts described in detail above were referred to as freak-offs, among other names. The involved orchestrated sexual performances facilitated through drugs used that sometimes lasted days at a time. This is not all. Okay. This is not all. As set forth in the indictment, the charges against the defendant captured significant additional violence, both spontaneous and premeditated. On numerous occasions, the defendant, okay, let me put my phone down because I'm seeing stuff. On numerous occasions, the defendant, assaulted women, employees, and others when he became enraged. That's what she said in here. That's what she said in her book. Assaulted women, employees, and others when he became enraged by throwing objects at them, choking them, pushing them, kicking them, and slamming them against walls and on the ground. The defendant and other members and associates of the enterprise were also capable of premeditated violence, resorting to kidnapping and arson when the defendant's power and control were threatened. The defendant's violence, whether spontaneous or premeditated, had the effect of exerting his continued control over these individuals. The defendant also carried firearms. The defendant also carried firearms to intimidate or threaten others. Multiple defaced semi-automatic rifles were covered when law enforcement searched the defendant's residence in March 2024, including 2 defaced rifles that had been disassembled and hidden in the defendant's closet. In short, the conduct with which the defendant is charged shows a pattern of violence and abusive conduct, underscoring his dangerousness. Okay. Is this the right page? Okay. This disposition to violence cannot be reasonably prevented through bail conditions. The violence alleged in the indictment was not isolated or arbitrary. It was systematic and pervasive. The defendant abused women with whom he was in personal relationships, employment, witnesses to his crimes, and others. Also described above, the defendant has sexually, physically, and emotionally abused long-term romantic partners for decades. Right here. It's right in here. including by forcing them to engage in freak-offs. It's in the book. The defendant also abused countless others in his orbit, and in particular, women, without regard for consequences. Indeed, the defendant's abuse of women long Indeed, the defense abuse of women long predates the conduct charged in the indictment. To date, at least 5 women have publicly accused the defendant of violent sexual assaults that date back to the 1990s. All right. Somebody said his goose is good and cooked. All right. Moreover, the defendant's violence and abuse occurred behind closed doors, including in his homes, hotels where he was staying, and other private settings. He has assaulted victims, employees, and others. Where are the men? I want to put that in here. Where are the men at? And even brandished a firearm to a victim in his homes. At a victim in his homes. The alleged sex trafficking similarly took place in private settings, not easily monitored. Indeed, in addition to engaging in freak-offs at hotels, the defendant has at times organized freak-offs at his home or at the homes of his female victims. This is precisely the kind of violence that even strict conditions such as home incarceration cannot prevent. So they don't want him to have freak-offs at the house while he is on detention or whatever the case may be. All right. In sum, the defendant's long history of violent conduct makes clear that even the most stringent bail conditions will not suffice to ensure the safety of the community. The defendant is a serial abuser who repeatedly assaults and coerces women to achieve his own sexual gratification and uses his vast wealth and position of power in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. The defendant's long-standing pattern of abuse is prohibitive evidence of the likelihood that he will continue to abuse. Indeed, nothing, not even the threat of public exposure or law enforcement intervention, has stopped his abuse. The defendant has continued to physically assault and threaten those around him, including his romantic partners, his employees, and others who happen to be present when he succumbed to fits of rage. It's in the book. No bail conditions can address the defendant's tendency to become violent when angry or emotional. Anyone in his presence is at risk of abuse or assault. The defendant's physical assaults are serious and resulting at times in serious injury, requiring medical intervention and long periods of recovery. Therefore, the nature of the seriousness of the danger to any person is both real and specific. Revising district courts released the defendants who had no criminal history, both had history of domestic violence. Okay, I don't think you all can see this part. Okay. As part of the charged racketeering conspiracy, the defendant engaged in obstruction of justice, including bribery and witness tampering. Given the defendant's history of engaging in obstructive conduct to conceal his criminal activity, both personal and through intermediaries, there is every reason to believe that the defendant will continue to engage in such obstructions if released. All right. As described in the indictment, following a freak-off in March 2016, the defendant attempted to bribe hotel security staff to prevent hotel security from publicly disclosing and or reporting to law enforcement his vicious attack on a woman attempting to leave a freak-off. The defendant's effort to disclaim responsibly from that attack continued until earlier this year. A civil lawsuit was filed. This is talking about Cassie. A civil lawsuit was filed on or about November 16, 2023, alleging years of sexual assault, verbal and physical abuse by the defendant, including allegations describing the March 2016 incident. Following the filing of the lawsuit, the defendant stated in no uncertain term, let me be absolutely clear. I did not do any of the awful things being alleged. That's what Diddy said. Through counsel, the defendant vehemently denied these offensive and outrageous allegations, describing that the complaint as riddled with baseless and outrageous lies. It was not until the video surfaced. It was not until the video surveillance footage of the defendant's attack was leaked to the media months later that the defendant was forced to admit that he had, in fact, perpetrated the disgusting act. Okay. More recently, the defendant has directly and through intermediaries engaged in obstructive conduct related to the matters under investigation in this case, specifically following the November 2023 lawsuit. The defendant and intermediaries acting on his behalf reached out to potential victims and witnesses to the alleged conduct, including individuals he did not speak to regularly and had not spoke to in years, to attempt to feed those victims and witnesses false narratives about the defendant's criminal conduct. With respect to at least two of these individuals, the defendant's co-conspirators assisted in effort to protect the defendant. For example, on or about November 19, 2023, just 3 days after the filing of the lawsuit described above, the defendant made multiple calls to other victims of his sexual abuse and recorded certain of those calls using the cell phone of a co-conspirator. During the calls, the defendant repeatedly asked for the victim's support and friendship, an attempt to conceal the victim that she had willingly engaged in acts of sexual abuse. The defendant also assured the victim that if she needed the defendant too, she ain't got worry about nothing else. That's what it says. She ain't got worry about nothing else. That's what it say. A thinly veiled attempt I can't even get this word right. A thinly veiled attempt to what is that? Conceive? I can't even get my words right today. The victim into adopting the support. the victim into adopting and supporting the defendant's false version of attempts to protect the defendant. Oh, okay. Okay. Even more convincing, since learning about the criminal investigation, including following the execution of the search warrant at his residences, Combs contacted other witnesses on multiple occasions, including other witnesses who had received grand jury subpoenas. Princess! The defendant's recent conduct in similar, I don't know. Yeah, thank you, Cookie. Right. The defendant's recent conduct is similar to that in United States versus LaFontaine, in which the Second Circuit affirmed that the district court's revocation of pretrial release after the defendant in that case engaged in witness tampering. Specifically, the defendant, who was charged with the multiple counts of fraud in connection with providing false claims to medical insurers, called a witness to remind the witness that a particular patient had received surgeries that the patient had not. In fact, received the Second Circuit affirmed that the district court finding that there was no condition or combination of conditions that would assure that the safety of the community, given the defendant's witness tampering, despite the fact that the defendant's tampering did not include actual violence or threats of violence. Whew. Okay, that's just. You said Terry tonight. What I got a Terry for? Hold on, y'all. Why do y'all? I'm live, Saints. All right, Dana. Thank you, Auntie. Y'all make sure y'all hit that donation button. I sure do appreciate it. Rejecting the defendant's arguments that the district court's findings of dangerousness was not justifiable, the Second Circuit noted that the defendant had fed the witness false testimony with the expectation that the witness would adopt it. This is why I have to turn my phone upside down. Folks is calling and texting. And that even stringent electronic monitoring conditions would be circumvented. Okay. Here, the defendant's conduct goes beyond what the LaFontaine court found sufficient to revoke bail. Even before being charged with the crime, the defendant has taken numerous proactive steps to tamper with potential witnesses. Testimonies against him. The government is aware through electronic devices, toll records, conversations with witnesses, and other evidence that the defendant has contacted witnesses, including subpoenaed witnesses, prior to the dates on which the witnesses were required to appear before the grand jury. In addition, the defendant has recorded calls with at least one victim and provided either directly or through intermediaries false narratives of events that transpired so that those witnesses would adopt that false testimony. Moreover, the defendant's obstructive conduct is made even more alarming by the manner in which he carried it out to evade detention. In some instances, by having intermediaries make calls on his behalf and recording certain calls on other individuals' devices, these deliberate actions show that the defendant was aware that what he was doing was obstructive and that his aim was to evade detection. Even the most stringent conditions, including the monitoring of a court-authorized electronic device, which is an ankle monitor, would fail to ensure that the defendants would not engage in this kind of obstruction from his home, including by acting through intermediaries using others' devices. Given the defendant's history of obstruction, as well as the violent nature of the crimes against the defendant, the defendant cannot overcome the presumption that no condition or combination of conditions can ensure the safety of the community. Sounds like this book. That's what it sounds like, this book. Okay, let me move this up some. Okay, I don't think I'm going to be reading all of this. Nor can the defendant overcome the presumption that he risked a flight. The crimes that the defendant is charged with carry significant penalties, including a mandatory minimum sentence of 15 years, imprisonment and a statutory maximum sentence of life in prison. Ooh! Baby, they must be finna get him for Pac. Oh, they must be getting him for Pac and Biggie. Ooh. The possibility of substantial sentence is a significant factor in assessing the risk of flight. Nothing that substantially sentenced defendant may face weighed in factor in finding that the defendant was a flight risk. Okay, let me try to skip past all these numbers. Yeah. Oh Lord. Right. Hold on. Get my little word out. Okay. The steeper and potential sentence, the more probable. The steeper the potential sentence, the more probable the flight risk is, especially considering the strong case of the government. Citation omitted. Here the defendant is facing at least 15 years imprisonment if he is convicted. Oh my God. The possibility of a substantial sentence is a significant factor in assessing the risk of flight. All right, I already read that. Got that. Here, the defendant is facing at least 15 years imprisonment if he is convicted. This fact alone would provide a compelling incentive for anyone to flee from prosecution. But the incentive to flee is especially strong for this defendant, who at the age of 54 faces the very real prospect of spending a substantial portion of the rest of his life in prison. Jesus. Diddy, you go in jail, let me see something. If they give you 15 years, Diddy, which they said that's a minimum. 15 years. You're going to be 70 years old.
Oh, Lord.
Oh, Lord. Oh. As detailed below, the evidence in this case is incredibly powerful, as the facts set forth in the indictment and herein makes plain. Dozens of victims and witnesses have provided detailed, credible, corroborated information against the defendant. These individuals include many who personally experienced and witnessed violence and other crimes at the hands of the defendant. Hold on. There we go. Moreover, these accounts are well corroborated by significant extras. I didn't say that word right. Evidence, including financial and billing records, travel records, electronic data, and communications, including extensive communication by and with defendants himself. For example, victims' testimony regarding freak-offs is at times corroborated by other witnesses. Now, this is my question. Y'all. Let's just stop for a second. Are they, because this is what this is looking like. Are they charging him for being a freak? You know what I'm saying? Or are they charging him for the abusive nature? Because I'm seeing sex workers in here, and I'm seeing intimidation and all this other stuff like that. And so it sounds like for the most part, they're charging him for the freak offs. Because that's what I keep reading. Maybe I'm wrong. For example, victims' testimony regarding freak offs is at times corroborated by other witnesses, testimonies, communication, defendants with the defendant, and commercial sex workers. Oh, somebody said all of the above. Okay. Travel records, hotel victims, physically abuse may be corroborated by among other things, videos of the abuse, photography of injuries, reports made by law enforcement, communication with the defendant and others, the testimonies from other witnesses who saw or heard about the abuse, the vast and varied sources of evidence described in detail above will be compelling evidence of guilt at any trial in this case. Thus, the serious risk of conviction provides further incentive for the defendant to flee persecution. Moreover, in this case, risk of flight is argumented by the nature of the evidence the evidence against the defendant. The evidence against the defendant, which would be made public at trial, includes substantial evidence that is highly sensitive and has the potential to significantly and negatively impact the defendant's reputation. For example, dozens of video recordings created by the defendant of freak-offs with victims. For decades, the defendant has spent significant time and resources ensuring that his criminal conduct avoids public scrutiny. Given the potential penalties here, both incarceration and reputational harm, the defendant has every incentive to flee the above reputation, and a public trial incentive to flee naturally bears upon and increase the risk of flight. The shame of the allegations that he is facing is also an immense incentive to flee. The defendant's incentive to flee outlined above, coupled with the defendant's seemingly limitless resources created Limitless resources created significant risk of non-appearance. The defendant's net worth is publicly. Cool. The defendant's net worth is publicly estimated at being close to $1 billion. Indeed, Diddy, you going down. You going down. Just going down.
Oh, Lord.
Jesus. Indeed, the investigation of this case has revealed that the defendant has access to vast funds and resources, including deep reserves of cash, which would facilitate his evasion of prosecution. At least as of December 2023, the defendant had access to dozens of bank accounts, some personal and many under corporate entities. Hey. Okay. Does the bank accounts, some personal, some which contain millions of dollars. Additionally, as of December 2023, the defendant had over $1 million in a personal cash. Wait, the defendant had over $1 million in personal cash on hand. The defendant has traveled internationally several times per year since at least 2006. And since approximately 2019, has owned a personal plane on which he has traveled internationally. The defendant maintains two primary residences in Los Angeles and Miami. In addition to his private plane, the defendant owns multiple vehicles in multiple locations. He has, okay. Okay, there we go. We'll have to go to the next page because that does not go with that page. He has a personal staff, including assistants, security, chefs, trainers, and others who perform tasks at his command, including transporting him, delivering him currency, securing narcotics for him, and other tasks. Jeez. And he is extra. Lord, they didn't put, baby. Did you go to jail? You go to jail. Oh,
Lord.
He is extraordinarily well connected both within and outside the entertainment industry. In short, if the defendant wanted to flee, he has the money, the manpower, and the tools to do so quickly and without detection. The defendant's lack of access to his passport or private jet would not negate the fact that the defendant could easily buy his way out of facing justice. Baby, they try to lock his money up. Oh, Diddy. Oh, baby, they try to make sure. Wait a minute, hold on, y'all. Oh, wait a minute. Okay. Am I on the right thing? Yes. As discussed below, the defendant's legal team has attempted to mitigate the substantial risk of flight by taking steps such as taking his family's passport, attempting to sell his plane, and reporting his whereabouts to the government. These steps have been with the precise goal of crafting an argument of bail before the court. While the defendant may have made the calculated decisions in consulting with his attorneys not to flee before any charges were filed, that calculus inevitably changes today when an indictment charging the defendant with extremely serious offenses carrying a numerous potential penalties was unsealed. He is now, for the first time in his life, facing a mandatory minimum term of imprisonment of 15 years and a maximum term of imprisonment of life. God.
Oh, Lord.
Oh, Jesus. In which the government is prepared to prove the charges against him by, among other things, the testimony of dozens of witnesses and victims to his serial abuse, and evidence from dozens of his own electronic devices and those of his co-conspirators. Given the serious nature of the charges, the strength of the evidence, and the defendant's access to vast amounts of resources, his risk of flight is more pronounced today than it's ever been. Ooh. Baby, Cat Williams was definitely right. Baby, they is not playing this year. Weight of the evidence. In considering the damage and the risk of flight presented by the defendant, the court is also required to consider the weight of the evidence against the defendant. The defendant faces a strong and powerful case here, only magnifying the danger he could present to others, especially victims and witnesses ready to testify against him. The risk he flees, testify against him, and the risk he flees. The evidence in this case consists of vast amounts of victims and witnesses' testimony, electronic evidence, physical evidence, and subpoena returns, and other voluntary productions, among other things. As the witnesses to date, the government has conducted interviews with over 50 victims and witnesses, many of whom saw or experienced the defendant's abuse. Many of these witnesses corroborated one another, and their accounts are similarly consistent with other types of evidence discussed below. The government only expects that number to continue to grow, even that the investigation, which is now public, is ongoing. The electronic evidence is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses. Setting aside devices seized in connection with the defendant's arrest, the government has obtained over 90 over 90 cell phones, laptops, cloud storage accounts. Baby, that's what she said in here. Hold on. Let's go back. Let's go back. She said it right here. Oh, she said it right here. Oh, it's right here. Here we go. That's not it. Okay, here we go. Baby, this stuff is... Okay, I'm gonna go back to that one. So in this on chapter 19, listen at this. Things were okay for a while. I started dating again. It was almost normal until I got serious with someone. Then my boyfriend died of pneumonia. I knew it was Sean. Again, that's when I decided to write this book. A few days ago, my home was burglarized. Only laptops were stolen. I knew it was that bastard his goons, co-conspirators. Of course, I had a copy in the cloud that I was able to easily download here on this new laptop. As I continue to write now, I'll send this into the cloud as well. I will send out copies via email. My Google Drive password will be attached, so the missing chapters can be accessed. This book must get out. There are so many more chapters to add. Hear that. There are so many more chapters to add. This outline is a great start. I have to organize the rest of the chapters and add them little by little. All right. That's why I still believe the book. I still believe it. The electronic devices is similarly vast. The government has sought and obtained numerous search warrants for such evidence, in addition to obtaining evidence voluntarily from certain victims and witnesses. Setting aside devices seized in connection to the defendant's arrest, the government has obtained 90 cell phones, laptops, cloud storage accounts, as well as over 30 other electronic and storage devices, such as hard drives, thumb drives, cameras, and surveillance systems. This electronic data comes from the defendant himself, as well as co-conspirators, victims, and witnesses, and chronicles much of the defendant's criminal activities as it occurs. Jesus. The defendant also consists... Oh my Jesus. Okay. The evidence also consists of physical evidence, which was seized pursuant to search warrants executed at the defendant's residence in Los Angeles and Miami, as well as his person and the person of as well as on his person and the persons of certain co-conspirators. In addition to the firearms and electronics discussed above, the physical evidence also includes other evidence of freak-offs, including over 1,000 bottles of baby oil and personal lubricant. Finally, the evidence includes... This the thing. This is the stuff that makes it salacious. They'll sit out here and tell you about the 1,000 bottles of baby oil and lube and stuff like that, but they don't tell you all about the rest of this right here. You know what I'm saying? Finally, the evidence includes records obtained pursuant to over 300 grand jury subpoenas and other voluntary productions. These materials come from over 100 entities and individuals, including communications providers, tech companies, social media companies, banks, and other financial institutions, airlines, hotels, car services, and other travel-related companies, escort services, and even the defendant's companies and wealth management firm. Together, this evidence, as well as other evidence gathered, powerfully demonstrated the defendant's guilt and counsel in favor of the detention. All right. For all the reasons set forth herein, I got this right. Let me lift this up for y'all. Nikki, do you want me to drop the link so you can read, baby? Is that good enough for you, baby? Okay. For all the reasons set forth herein, there is no bail package that can reasonably assure the safety of others in this case. Where the defendants had engaged in decades-long patterns of violence against women and others, and has used his wealth and power to assure that his criminal conduct goes unpunished through manipulated and obstructive conduct, in particular, the bail package proposed by defense counsel is insignificant because it fails to adequately protect others from the defendant's violence, impose measure to prevent to prevent and detect obstruction, or prevent the defendant from accessing his vast resources, including millions of dollars in cash, to evade prosecution, or dissipating those assets to avoid financial penalties for his crime. Defendant's counsel has proposed certain bail conditions, including home detention, which electronic monitoring and including home detention and electronic monitoring and a $50 million bond secured by the defendant's Miami property. These conditions are plainly insignificant to address the legitimate concerns set out above. In particular, given the defendant's history of engaging in obstructive conduct, the court must reject the insufficient conditions proposed by defense counsel, which do nothing to prevent and detect such conduct. For example, a case in which the defendant was charged with witness tampering and where obstruction remained an ongoing concern. The Second Circuit Court revised, am I reading this to you all right? Yeah. Revised the district court's release of the defendant on bail conditions because the $1 million bond, which has to be secured by properties owned by the defendant and the members of his family, only deterred flight, not danger. More specifically, the Second Circuit found the district court's bail conditions intended to address witness tampering, which was a general prohibition. I can't even get my words right. A general prohibition, and the defendant was not to commit a crime or intimidate a witness, does not at all impede his ability to do so, and requires no more of him than that which is law already demand, All right. Notable, the defendant previously proposed conditions. Notably, the defendant previously proposed conditions do not include provisions related to his access to electronic devices, which, as outlined above, the defendant uses to engage in obstructive conduct. Nor did the proposed condition include information that related to or restrictions on access to the defendant's vast resources, including multiple personal bank accounts, in the name of defendant's business, and deep cash reserve, which could facilitate the defendant's flight. Similarly, the proposed conditions fail to protect against dissipation of assets, which may be subject to forfeiture or penalties on the charges of the indictment. Finally, the proposed conditions do not include conditions that would limit the defendant's potential to engage in violence or abuse, such as drug testing and treatment and surrendering of all firearms. In conclusion, as set forth above, the defendant poses an ongoing and significant danger to the community, has repeatedly engaged in obstructive conduct, and presents a serious risk of flight. The government respectfully submits that the defendant cannot meet his burden of ongoing statutory presumption in favor of detention. There is no condition of bail that would assure the appearance and compliance of the defendant or safety of others. Accordingly, any application for bail should be denied. Respectfully submitted, Damon Williams, United States Attorney. Okay. So I need everybody to hit that like button. If you're not subscribed, make sure you subscribe. This right here, Damon ain't playing. It's consistent with everything that's even in her book. They got him on. From reading this and even understanding this, they have him on all of the illegal activity. I don't even know if they're trying to charge him with Biggie and Pac's death, but from the 15 years to life, baby, they trying to lay it to him. Because from what I'm seeing, who? Oh, wait a minute. Wait. Okay, can y'all hear me? Can y'all hear me? Can y'all hear me? I'm on my other device. Can y'all hear me? Okay, good. All right. Let me go and try to finish this up real quick. Okay. So Damon Williams. Oh, like what the world is going on in my ear? Okay. Damon Williams, the United States Attorney for the Southern District of New York, announced that Lamar Whitehead was sentenced today by the U.S. District Judge Lorna G. Schofield to 9 years in prison for wire fraud, attempted extortion, and making false statements to federal law enforcement agents. Whitehead was previously convicted on all charges following a 2-week trial. Now, this is what he said. U.S. Attorney Damon Williams said Lamar Whitehead is a con man who stole millions of dollars in a string of financial frauds and even stole from one of his own parishioners. He lied to federal agents and again to the court at his trial. Today's sentence put an end to Whitehead's various schemes and reflects this to offices committed to bringing accountability to those who abuse their positions of trust. So Damon Williams not only has prosecuted Diddy, he didn't prosecute Lamar Whitehead too. So baby, these folks ain't playing. These people are not playing. Diddy, baby, these folks have prosecuted Whitehead, and they prosecuting you too. As they say, I would say pray your strength in the Lord. Right, now clock that T. Clock that T. To me, I'm gonna tell y'all like this right here. Okay, you hear me good. Wire fraud through the church, and through the hip hop community. Now, I was on, okay, good. Oh, it's working. It's working. Oh, it's working. Let me see something. Can I? Hold on. Can y'all hear me? Hello, Saints. Can y'all hear me? Let me know if you can hear me. Oh, my little thing came off. Can y'all hear me now? I was on with WAC 100. Okay, I'm gonna try not to move. I was on with WAC 100, and WAC 100 even asked me, do I think that Lamar Whitehead had involvement with Eric Adams and sliding money through the church? I said, that's really hard to believe because Lamar Whitehead, his church was so small. But then Lamar is driving a Rolls Royce, and he's driving a Cullinan. So now you got Lamar, Diddy, and Eric Adams. So ain't no telling what and Lamar was connected with a lot of people. So ain't no telling how this money was funneled. How in the world did Eric Adams get $10 million? That's what we're trying to find out. How in the world did Lamar, Eric, and Diddy make sure this man get $10 million? Y'all make it make sense. Make it make sense. So while people are trying to worry about me reading this stuff, at the end of the day, when I read the whole entire book and it was like 3 hours, everything that's in this book lines up with what's in this indictment. You think they're finna let this man get off? And now we're putting the pieces together? Oh, baby, Where's my cash at? Where's my cash app at? When I read this whole book, and I'm like, let's put the pieces together. Because for so long, we've been trying to figure out how Tupac died. Who killed him? For so long, we've been trying to figure out how Biggie died and who killed him. But now, when you read this indictment, it goes right along with what's in this book. Abuse, co-conspirators, making sure like wiretapping people's phone, and you're using the government people to do this type of stuff. Who are you connected with in the government? What makes you think why all these people are stepping down? Because it sounds like y'all had some allegedly, it sounds like y'all had some involvement in a lot of this bushwanky that was going on. That's what it sounded like to me. That's what it sounded like to me. Now, I'm just a vlogger and a commentator. I'm giving you my thoughts. These are my thoughts. And it's absolutely. Oh yeah, they're probably going to use the book as evidence too, because they even said in the indictment that they had to go and get clouds. They had to go and get evidence from the clouds. What does that say? If they got to go and get evidence from the clouds, baby, you cooked. Baby, you cooked. Baby, they finna go and get all of Kim Porter's documentation and things that she typed from the cloud. Baby, Kim Porter is alive and well via spirit. And baby, she is going to get her get back for every single thing that you did to her. Because even though her staying with Diddy, she was dumb and stupid, baby, she stayed with him out of fear for her life and fear for her children. Now, that's what I want her kids to understand. The things that this is what I want her kids to understand. This book may sound far-fetched because you never saw any of this from your daddy. And then again, some of y'all probably did, because Justin, Christian, and Quincy, baby, I'm sure y'all saw something. Because y'all was up here giggling behind a little white girl. Okay? So for you to sit out here and say, I don't believe that my mama couldn't write no stuff like that. Oh, baby, yes. And she even said out of fear for her children. Out of fear for her children. Yeah, King act more like his daddy. Absolutely. Absolutely. So the thing is, it's like this is going on. Now they're taking and you know what? And hear me out when I say this. Right. Baby, that spirit of Celadon came back in the form of Kim Porter. Until you do right by me. Huh? Until you do right by me. Everything you gonna do. What? Everything you gonna do is gonna ride. Maybe you're gonna be sitting right in jail talking about some.
Any more letters come?
Oh yes, you're gonna be sitting right in jail talking about some.
Any more letters come?
Yeah. Because you fucked around and found out, baby. You see, this is the thing. Diddy was out here trying to do some spiritual work and was out here trying to, according to Kim, says he was doing some voodoo and stuff like that. Baby, let me tell you something. One thing I do know, and I've been in church my entire life, baby, I'm COGIC, and I know all about the workings of the workings. Baby, I know who doing it and who ain't doing it, who for real and who ain't. At the end of the day, you have to be careful when you play with magic. Dark magic, spiritual works, whatever the case may be. You have to be careful of what you're doing. Because, baby, if your intentions, I don't care what your intentions are, you got to make sure that stuff is right, because that stuff will come back and bite you in the ass, okay?
Any more letters come?
That's all I'm trying to tell you. That's all I'm trying to tell you. And see, for the simple fact that even she said in here that this man made her perform, I want to say it was sex magic. Because she even said when she first got pregnant, he wanted that energy. She had to have sex with multiple people while she was pregnant. Now, for everybody that's out here talking about the book ain't real, the book ain't real, the book ain't real, baby, read this indictment. Read this indictment. The math is mathing. And although I hate to see a black man go to jail, especially somebody who has worked so hard in the industry, somebody who has paved the way, and even though he didn't pave the way right, but he's paved the way and he's climbed the ladder. I hate to see a black man like this go to jail. But sir, how you got to the top? How you got to the top? And allegedly you done knock some people off on the way up to the top. Baby, spirit is working. Baby, spirit is working. Y'all don't hear me. Spirit is working. Y'all ain't talking to me in the comment section. Baby, spirit is working. Baby, Sloan, Sloan Bella said it too. And what's so crazy is it's a lot of people out here that want to put salacious things out here. But look at you got a medium that came out and said something. Jesse said the Lord is outside. Baby, God is not playing. You hear me? God is not playing. And for everybody that's out here talking about, oh, I don't believe this. Let me tell you something. People are not mysteriously dropping dead. You hear what I'm trying to tell you? People are not mysteriously just dropping dead. Oh, they got a cold. Oh, they got pneumonia. No, I'm going to say it again. People are not mysteriously dropping dead. That's why a lot of things I don't even worry about. When you do right, victory. What am I supposed to say?
Oh, Lord.
When you do right, victory always prevail. I'm going to say it one more time for them folks back in the back. I don't care what you want to call it. I don't care what people perceive or whatever the case may be. Victory always prevails. Maybe you can get mad about it if you want to. You can feel some type of way if you want to. Victory always prevails. Do you hear what I'm trying to tell you? This woman died. Well, 2018, she getting her victory. Baby, everything is being exposed. And that's not going to be the only person. Because I don't care. I don't care who it is. That go for church folks too. You may think you getting by now. Oh, baby, I remember the old folks saying it all. You may think you getting by now. You may think you're getting by now. But baby, the piper is coming to collect payday. Do you hear what I'm trying to tell you? The piper is coming to collect payday. You may not like it. And that's what's comical to me. People always, they feel like by shutting down, I'm going to say it like I want to say it, sister. I'm going to say it like I want to say it. You may think that you're shutting victims down. You may think that you're shutting the person that is the mouthpiece down. But sooner or later, Miko, where you at? Sooner or later, justice will prevail. And the fact that you call yourself trying to shut down victims and intimidate people, baby, they got it all in this. They got it all in this indictment right here. Intimidating. So be careful what you do. Did y'all support the Cash App today? Did y'all support? I'm just so tickled. My soul is blessed today. Did y'all hit the Cash App? Make sure y'all support the Cash App today. Make sure y'all support the platform and everything like that. I'm going to tell y'all this before I get ready to go. And that is, I hate to see a bunch of black men, especially black people, go down like this. But I'm quite sure it was other talented people that were right along in that same line with Diddy. And the reason why I added Bishop Jakes is because at some point or another, Bishop Jakes ended up at this man's party. Now, here's the thing. From what I know, it's been a lot of people, especially gospel artists, that have come through these parties. Okay? Because I'm looking at Kirk too. Because Kirk up there twerking on the Clark sisters and stuff. And I know the Clark sisters been through the Diddy parties. I believe Kirk Franklin been to the Diddy parties. And y'all doing all this other stuff. And this stuff ain't godly. It ain't in the name of God or anything like that. Because how do you think these people get to the top in the church world? It ain't because of gifts. It ain't because you can preach real good. Because half these folks that's in the preaching circuit, baby, y'all can't preach, and you definitely ain't got no oil on your life. Hello. So Bishop Jakes, I ain't got no problem. I ain't got no problem. Bishop, I just want you to make sure your nose is clean. Make sure your nose is clean. Make sure everything about you is right. Okay, hello. Have y'all enjoyed the show? Please make sure y'all go and hit that Cash App. Make sure y'all support the show. Make $8 to $10. That's all I ask for. Just support the show, support it, and everything like that, baby. I knew I was gonna get through this indictment today. But anyways, I want y'all to make sure y'all support. Make sure y'all come back when we do another show. Today Friday? Oh God, I didn't know today was Friday. Jesus. Wow. Today is Friday. Such a good day. Anyways, well, I do plan on coming on tonight, right after this good hurricane. Me and my brother and the whole gang, we're going to come on tonight. We're going to talk about the things of the things. So you make sure your mama and them and your daddy and them and your pappy, your grandmama and them and everybody, y'all come on tonight, okay? I love y'all. Peace out. Talk to y'all later.